Good morning. Can you hear me okay? It seems kind of quiet. Okay. So my name is Jasmine Gonzales Rose, and I'm an assistant professor of law at the University of Pittsburgh School of Law, and I have the pleasure of having served as the faculty advisor on this symposium to the Law Review. So I'd like you to welcome the student leader organizers of this event. First Caleb Pittman, and then Megan Block, respectively the editor-in-chief and lead executive editor, who will join me in welcoming you to the symposium, Challenging Authority, in honor of Derrick Bell.
Good morning, everyone. My name is Caleb Pittman. I'm the editor-in-chief of the Law Review, and I just wanted to thank you all for being here and thank our speakers for sharing their work with us yesterday and today. So I spoke yesterday about Derrick Bell's incredible life, and I just wanted to reiterate a few key points today. Derrick Bell was from Pittsburgh. He was born in the Hill District. He was the first in his family to attend college, and after serving in the military, he went on to attend the University of Pittsburgh School of Law as the only black student in his class. He also was on the Law Review as an associate editor-in-chief, and he had a very distinguished career afterwards. He went on to work for such places as the Department of Justice, the NAACP, Harvard Law School, Oregon Law School, NYU, and near the end of his life, he came back to serve as a distinguished visiting professor here at Pitt Law. I first encountered Derrick Bell's work as an undergraduate in a Race in the Law class at the University of Louisville. We were assigned his casebook, Race, Racism, and American Law, and I found his work very challenging, very intellectually stimulating, and even though many of the ideas in it were very controversial for me at the time, it was also very inspiring, and it was very inspiring to learn about his life, which was a very principled life. He was not afraid to challenge authority when he saw something that was wrong, and not afraid to take a personal loss in order to stand up for his beliefs. And so when I found out I was going to be attending Pitt Law, I thought, I wanted to do something to kind of honor this person who inspired me to go to law school. And he passed away right around the time I came to Pitt Law. And when I found out I was going to be on the Law Review and we were coming up on our 75th anniversary, I wanted to use this opportunity to really celebrate his legacy here. And I really initially did not imagine anything quite like this, and it's really grown into something much bigger and better than I could have dreamed, and I'm just very honored and excited to be here today with all of you. Thank you.
Good morning. Welcome. We are so excited to have you all here. As we were talking about yesterday, we read the abstracts, we read the bios of all of our distinguished speakers and our roundtable participants, and it's just amazing to watch that come to life. So thank you so much for coming, and I think we're in for another extraordinary day. I just want to take a moment again to thank our co-sponsors who made this event possible. So thank you to the School of Social Work here at the University of Pittsburgh and Dean Larry Davis. Thank you to the Center on Race and Social Problems and Ralph Baines. Thank you to Reggie Shuford and the ACLU of Pennsylvania, to Barb Frege and the ACLU of Greater Pittsburgh, to Rashad Birdsong and the Community Empowerment Association, and finally to Shiira Powell and the Black Law Student Association. The event would not be possible without you, and I really think the well-rounded nature of our co-sponsors illustrates the depth and the broad appeal of Professor Bell and his work. So thank you so much. It's going to be a great day.
So in addition to these wonderful student organizers, these leaders, and our co-sponsors, this event absolutely could not be possible without the tremendous support and encouragement of Dean William Carter. He has been amazing. So he came to Pitt Law only 2 years ago, and he has really brought so much energy, so much focus, a brilliant scholar focusing on works dealing with the 13th Amendment, and he is taught in the area of constitutional law, critical race theory, and civil rights. Who better to welcome right now than Dean Carter?
Good morning, everyone. I'm going to use my law professor voice so you all can hopefully hear me okay. It's a pleasure to be here. I have the privilege of welcoming you to the Law Review's Symposium Challenging Authority, a symposium in honor of Derrick Bell. I am going to be purposefully brief. There's an awful lot I could say about Professor Bell as one of the most distinguished alumni of the University of Pittsburgh School of Law. A lot I could say about his scholarship, since some of my scholarship is in the same fields and has been heavily influenced by Professor Bell's work. But rather than doing that, I'm going to cede those issues to those who knew him better, who knew him well, who've been engaged in these fields far longer than I have, and just extend a few words of greeting and thanks to you all, and then get out of the way so that we can get to the substance of the morning. Of course, thanks are due first and foremost to our students who had the idea for this and who brought it to fruition through an incredible amount of work and creativity. Professor Gonzales Rose has been a real stalwart in working with them and supporting them and bringing this all together. We would not have the opportunity to hear from the folks that we're going to hear from today without her work and the work of our students. And of course, we're honored and privileged, as we always are, by the presence of Mrs. Bell, who I think some of you know, but I don't know that you've all had a moment to meet her. So, Janet, if I could ask you just to stand and wave and be acknowledged. Janet will be sharing a few words with us once I get out of the way, but I think it was particularly important to note how honored we are to have her here and spending this time with us for this important and indeed signature event. You know, there's a lot to be said by Professor Bell, about Professor Bell, and to paraphrase a quote I heard very recently, for those of you who knew him, no words are necessary, and for those of us who didn't, no words are sufficient. I don't know how to add to the legacy of his life's work. It is visible, it is apparent, and it continues to teach us, all of us, whether we are currently students or more senior scholars in the field, quite a bit about the kind of person and the kind of life that he lived as an example for all of us. I believe it was St. Augustine who said, preach the gospel always, if necessary, use words, right? Professor Bell's life was his testament, and so I don't want to try to gild that lily. I think we're all quite aware of who he was, what he's accomplished, but I will note, as I did in the opening last night, what a particular honor it is to be the dean of his alma mater. It was truly a pleasure beyond compare to have the opportunity to serve in this role in its own right, but when you add to that being the dean of the school in the city that gave the world Derrick Bell, it is really heartwarming every day to think that I am some small part of his legacy. So again, let me welcome you all, let me thank you all. You are in for a real treat. The range of scholars who will be speaking today, both those from Pitt Law and from around the country, is beyond compare. So I know that we will have a good, rich, substantive, engaging, and challenging discussion of the kind that Professor Bell would want were he here with us. So with that, let me step aside and welcome to the podium Mrs. Janet Derrick Bell.
Thank you. Good morning, everyone. And so you said, were he here? He's in the house. And I just want to, on behalf of the Bell family, thank you so much. Thanks the University of Pittsburgh School of Law, Dean Carter, who was last year's Derrick Bell lecturer at NYU School of Law. They're still talking about how wonderful and brilliant it was. And I can't thank you enough for the support you've given. There are a couple other Bell lecturers who are part of this program, notably Richard Delgado, Ian Haney-Lopez, whom we've heard from. I want to underscore just a couple more points. It was interesting, I call him young Caleb, I can get away with that at my age, who came up and said, well, you know, when I got on the law review and I knew I was going to do something, I want to do something like Derrick Bell. He is the editor-in-chief of the law review. So I want to say that about Caleb Pittman and about young Megan Block, who is likewise self-effacing. She is the lead executive editor of the Law Review. And I know that it is a great commitment of their time to be involved in this. It grew into something which is really now a signature event. I can't talk about it enough. I've been texting people and telling people. I'm skipping an event tonight at NYU to be here today because this is the place I need to be. So I want to thank all of you for being here, and it's been wonderful so far, and I know it will continue to be a wonderful event. Thank you very much.
So I would like to start setting up our first panel, so if I could encourage our wonderful speakers to come and take seats here, and I'll be introducing them here in a moment. So I have the pleasure of beginning the first panel. Yesterday we had these magnificent round tables followed by Ian Haney-Lopez's opening lecture. And I think we were very energized and very inspired, and I know we're carrying over that energy today. So this morning, we'll be having a session talking about current issues in critical race theory and interest convergence. And there are some who may question, is critical race theory perhaps a historical sort of journey? Is that something that has once been done, has concluded? Or is critical race theory still alive? Is it simply reiterating the work of the founders and the forefathers and those mothers who came before? Or is it ever evolving and ever changing to really address these issues that Professor Haney-Lopez talked about last night, and the changing nature of racism and subordination in the United States? So what we have today are a group of innovative scholars who are bringing together new approaches to ever-changing issues. So first we have Patience Crowder. Patience is an assistant professor at the University of Denver Sturm College of Law, and we're so honored to have her here. She first joined that faculty in 2010 to create and teach in a community economic development clinic. Before that, she was a clinical professor at the Tulsa College of Law, where she taught a transactional legal clinic. Today, Patience is going to be speaking with us on the issue of alleviating suburban poverty. Next to her is Montré Carodine from the University of Alabama School of Law. I had the pleasure of meeting Montré a few years ago, and she is the sort of person that every young incoming law professor wants to be. She is incredibly inspirational. And I have to say, I started a project on critical evidence, applying critical race theory to the rules of evidence, and I was so surprised at how little work there was. And I had students, and I invited them to look into this work, and really she was the leader in this field, and her work is so interesting in the intersection of race and evidence and in so many other areas. And finally, we are going to hear from SpearIt, who is an associate professor at the Thurgood Marshall School of Law, Texas Southern University. And SpearIt has written extensively on criminal law and on critical race theory. I've had the pleasure of getting to know him through the Lat Crit community, where he has been a leader. He, in addition to his JD, he has a PhD in religious studies, and I always feel that he brings an extra dimension of depth. I've often been someone in the audience listening to him speak, and I'm so excited to hear him speak again because he has challenged my thoughts and really helped me to grow in addressing these issues. So there are more extensive bios in the program, and I'll refer to those because I know we're eager to hear the substance of their talk. They'll each be talking for about 20 minutes or perhaps a little less. Then we'll open up for discussion and so forth. So please join me in welcoming this panel.
Good morning. I want to thank Dean Carter and Professor Jasmine Gonzales Rose and Mrs. Bell and the Law Review staff for inviting me to participate in today's activities. This has been a real privilege for me. I was able to listen to the roundtable's discussions yesterday and just was really inspired and blown away by the work that folks are doing. And I'm incredibly honored to be able to participate in this symposium. It means a lot. And I fear that I'm getting a lot more out of it than I'm getting. And so I hope that I hope that I can pay that forward at some point. But I'm just happy to participate in today's talks. Before I get into the substance of my talk and explain what I mean about alleviating suburban poverty, and there's a colon there that it hasn't made it into the title because I keep going back and forth on the title of the article. What would come after alleviating suburban poverty would be through regional interest convergence. And so the idea that I'm talking about is the reconceptualization of Professor Bell's interest convergence theory and an application of state and local government law for a new regionalist strategy for improving poverty in metropolitan areas. And I'll explain what all that means in a few minutes. But there are a couple of things that I'd like to mention to set the talk up. The first is that I am by nature a business law attorney. I focus on community economic development efforts. And I have to say that this is my first experience with critical race theory as a scholar. I'm very much a novice in it and don't present myself as an expert. I've enjoyed the journey and I look forward to doing a lot more. So I'm very eager for comments and questions on the application of it. And just have appreciated the ability to delve into it. And that doesn't mean, sometimes business law is seen as a non-obvious setting for things like racial justice and social justice, and I don't mean to suggest that there aren't scholars who are doing that work. Professor Stephen Ramirez and Andre Cummings have been doing a lot about sort of corporate social justice and looking at issues along those lines. It's just personally a new experience for me. My scholarship to date is focused on inner city and urban economic development, which has been a natural segue into looking at issues of poverty in metropolitan areas. So I would like to talk a little bit about how I came to focus on this question, which really for me, where the paper represents sort of the beginning of what I hope are future scholarly pieces in a study on regional organizing and regional development. Alleviating suburban poverty through regional interest convergence. As I mentioned, this is a reconceptualization of Professor Bell's interest convergence theory, and this article proposes a new regionalist governance mechanism for alleviating poverty and promoting equity, regional equity and economic justice in metropolitan regions. Hopefully by the end of the talk you'll understand why I'm presenting it as a reconceptualization of the theory as opposed to a direct application. But there are two foundational pieces that I think are important to understand with respect to the argument. As was mentioned earlier, I teach a community economic development clinic. So I am a clinician at a critical race symposium, which means that I have a story to tell. So as a clinician, my clinic in Denver began representing a neighborhood in Denver that, depending on who you talk to, I should say neighborhood association, was either the poorest community in the state of Colorado or one of the 5 poorest communities in the state of Colorado. What that means is out of 1,500 homes, over 90% of them are public subsidized. There's a high ratio of turnover in the neighborhood because, as you can imagine, with public housing, a lot of folks are moving in and out for various reasons. A very rich tapestry of people of color residing in the neighborhood, Black, Latino, Somali, and Vietnamese immigrants. But they're also in a very prime area near where the Denver Broncos play. And so Denver right now is going through a regional transit planning process where we're expanding our regional transit. And this neighborhood lies pretty much in one of the lines where they want to put up a transit-oriented development project. So that's retail, public transit, and residential housing. So the residents, or at least the neighborhood association, are particularly interested in how the community can participate in the redevelopment project, and ask the clinic to participate with translating development documents into plain layman's terms for the residents, and then helping to prepare the residents for public comment at city council meetings and things of that area. And the representation actually was going fairly okay, but we had to withdraw because we needed to work with a community organizer to actually carry out the representation. That's not my skill set. Community organizing is a very unique skill, and we couldn't find an organizer to work in the neighborhood because the neighborhood was just that hard. Folks were not encouraged to be able to work with a group of people, not because of the personalities, but just because of the lack of capacity to participate in their own representation. And so because we didn't have a community organizer to work with, we could not carry out the representation. And it got me thinking about sort of this idea of isolated communities who don't have anyone who's even able to provide work in the space. And how can I connect my former client with other poor communities throughout the region so they could at least build social capacity and start to network beyond the boundaries of the city to build their own capacity and participate in this redevelopment project in a more thorough way. So that was when I first started thinking about this idea of regional work and regional development. The second thing that I started to think about and notice, everyone recalls, and we're still dealing with the impact of the Great Recession. One of the legacies of the Great Recession has been this idea of the expansion of poverty in the suburbs, the suburbanization of poverty. And it's gotten a lot of people thinking. The Brookings Institute has recently published a book by 2 researchers confronting suburban poverty in America. There are lots of conversations on NPR and other progressive shows about this expansion of poverty in the suburbs and what that means. And I really, as someone who's studied economic development and inner city revitalization, I pay attention to this idea of how do we fix poverty in the suburbs, and particularly because we haven't fixed it in urban communities. And so I started to wonder what it means if the focus shifts to how do we alleviate poverty in the suburbs without having adequately dealt with poverty in our urban communities. And that's certainly not to say that poverty in the suburbs is greater or worse than poverty in urban communities. And the reason why it's important to think about poverty in the suburbs is it's a phenomena, if I could use that word, that's happened as a result of the Great Recession. And what that means, and it's happening for a couple of reasons, I should say. I think we're all somewhat familiar, or maybe with the history of the development of suburbs in our metropolitan areas, and understanding that through economic and social segregation, the suburbs were fueled as a place where people could go to escape our center cities. And there's been lots of tremendous scholarship about that development and what it's meant for our progress as a nation. recently, the suburbs have become to be a different sort of place than how they were initially conceptualized. So the demographics in the suburbs are changing. They are a lot less white than they used to be. They're a lot less affluent than they used to be. And that's because of a whole host of things, from the relaxation of, or I should say, fair housing laws, strengthening, providing more affordable housing, people having means to move out of the central cities into the suburbs, and also recent immigration trends where folks, instead of locating in the center cities, are located into the suburbs, but also the economic impact of the Great Recession. Folks who were formerly affluent living in suburban communities have lost jobs. They went through their retirement, their savings, they lost equity, they lost their homes, high foreclosure rates. These are all things that we heard about and familiar with the subprime mortgage crisis. And so all of a sudden we have folks who were formerly affluent now living on the edges and also experiencing poverty in the same way that the community that I talked about, my community, my former client, Sun Valley, is experiencing poverty. A particularly unique difference about poverty in the suburbs is that the capacity of the suburban communities to provide relief to their residents is a lot different. Suburbs, as I mentioned earlier, were developed to be oases or escape destinations for folks who were getting out of the central cities, and they never anticipated needing to provide poverty relief, so they don't have the infrastructure. They don't know how to provide public services. They have limited means with respect to providing counseling and other types of services that people impacted by poverty are experiencing. And foundations are used to funding poverty alleviation mechanisms in central cities and urban communities and not really focused on the suburbs. So there's this tension of existing poverty in urban communities and this emerging poverty in suburban communities, where poverty, there are still more poor people living in central cities as a numerical matter, but poverty is growing at a much faster rate in suburban communities. And so combining this idea of poverty expansion in suburban communities, where we've got both formerly affluent communities and still affluent communities, with central cities, and just trying to figure out how do you tackle poverty at a much larger level, at a regional level. And really, it sort of became a thought exercise where I was just sort of brainstorming about how to fix the problem. I'm a transactional lawyer by trade, and just sort of thinking about what's the transactional fix for this issue? How can I make it better or provide more relief for communities that are like my client? And that's what led me to Professor Bell's interest convergence theory. Literally, how can these interests align? Knowing, oh, convergence, where have I heard that before? And it really was that sort of, it was sort of a roadmap to get me to think about whether or not I could make an application of the interest convergence theory. As I mentioned earlier, critical race scholarship is a new area for me, so it's been an interesting application of what I think is a very powerful strategy for providing relief to subordinated communities. And so I just really want to outline the way that I think interest convergence provides or can be used as a tool to provide relief to urban and suburban communities for the benefits of our metropolitan regions. And by metropolitan region, in case folks are wondering, I mean a central city like Pittsburgh that's surrounded by satellite communities, satellite suburbs, where there's a very strong interdependence between the central city and the suburbs that either is or is not recognized depending on where you are in the country. So I was getting a little nervous about articulating Professor Bell's theory as I understand it, because I'm always surrounded by people who know it much better than I do. But interest convergence theory, as identified by Professor Bell in his Harvard Law Review article, at a very sort of thinned out description, is he identified interest convergence theory as a way to explain the Supreme Court's decision in Brown v. Board of Education, essentially saying that the court ruled the way it did to desegregate our public schools because there was a convergence of interest between Black Americans seeking desegregation of public schools for their children, and elite white Americans who were concerned about things such as our country's reputation internationally with respect to race relations, stemming the flow of communism in African American community, and also removing a barrier to the industrialization of the South, removing segregation as a barrier to the industrialization of the South. And these interests converged in a way that the court felt or decided to desegregate public education because it didn't alter the status quo of the elite white Americans, right? No harm came to them as a result of this court decision. And so my thoughts about the application of that sort of went down this road. If we're talking about a way of finding interest convergence, what are the interests that we're talking about with respect to state and local government? For those of you who might be familiar, our conversations, the debate around state and local government really focuses on what's the best way to govern our metropolitan regions. And what's happened on the ground since the suburbs were first formed has been a localist approach. That means local governments exercise autonomy to govern their spaces as they see fit without regard to the surrounding communities. That's the way that localism happens on the ground. In the conversation, which has been ongoing for decades, a second voice in that piece is regionalism. Regionalism advocates support the idea of local governments working in concert together for the benefit of the metropolitan region for basically two reasons. Government efficiency, so that governments don't compete against each other, but then also for equity reasons, to ensure that there's a more equitable flow and responsibility between center cities and suburban communities. Regionalism has always been more of an idea, an academic concept, than localism, which is actually what happens on the ground, as I mentioned earlier. And regionalism started as a formal movement for formal regional government structures, right? So we have cities, we have counties, we have states. We don't really have regional government structures. And once it became clear that that movement was actually not going to go anywhere, what emerged, which is where I center my idea of regional interest convergence, is the idea of new regionalism. So the idea of informal governance mechanisms and cooperative agreements between local governments as opposed to formal government structures to carry out a regionalist approach to government efficiency and equity. So new regionalism is really an academic concept that's never been actualized. It's something that folks talk about but haven't quite found the way to get it on the ground. How do we actually effectuate new regionalism? And so I present regional interest convergence as a mechanism for actually doing that. The analogies that I made with respect to the idea of regional interest are these. As I mentioned with Professor Bell's theory coming out of the Brown decision, he identified the interest of blacks and elite whites. The way that I have conceptualized this in the idea of regional interest convergence are the interests of localists and the interests of regionalists as regional constituents whose interests can be aligned. Folks, regional constituents, the localists value autonomy, as I've already explained. They value the ability for localities to make their own decisions about their taxes, their zoning, what stores they want to recruit, whether it's Walmart or Target, what teams they want to build stadiums for, without interacting at all with their neighbors. Regionalists, on the other hand, are more concerned about sort of regional impact in the metropolitan region. So if we're talking about recruiting a baseball team, what does that mean for all the localities, and what's the best locality to situate that in? If we're talking about bringing in a potential employer, where are we going to build affordable workforce housing that's going to meet the needs of all the potential employees, and really looking at that on a regional aspect. And so these are the interests that I've identified that need to converge to effectuate regional interest convergence as a new regionalist strategy. So how could that happen? Particularly if we have people in the suburbs who really just want to live next door to other people who look like them, right? And that's probably always going to be a challenge that might not necessarily be resolved by this issue. But I think one of the best examples of regional interest convergence in practice is, why would these communities have interests that align? What's going to be the draw for that? And a good example, I think one of the better examples, is funding from the federal government. So the federal government has programs like the HOME program, the Sustainable Communities program, that require localities to actually work together and plan together on a regional level to get money from the federal government to execute economic development projects and commitments. And so the only way that this happens is for these localities that might not otherwise act together or act in concert to come together in a regional planning process to present an application that would entitle them to funding. And so this is where I see interest convergence happening on the ground in a way that hasn't been named. And one of the panelists at yesterday's roundtable talked about the importance to critical race theory of naming mechanisms. And this is why I think the idea of regional interest convergence, or how I think it can contribute, because right now we're going through a process that's been unnamed or unidentified, and actually a little bit ad hoc. No one's really focusing on the idea that this can be something that could be re-replicated. It's a great drawing, by the way. And so the goal would be to find a way to name the mechanism for regional interest convergence, and so that it can be implemented on the ground, and not just with respect to the idea of obtaining federal dollars for regional planning, but finding other ways for communities to come together so that both urban and suburban communities can do better about finding mechanisms for alleviating poverty in their areas. Thank you.
Good morning. Thank you so much for having me. Thank you especially to the law review editors and also to Jasmine. Thank you so much for that introduction. It was really sweet. And I'm a huge admirer of yours, and I just knew, when I met you when you were on the market, I knew that you were going to be a star. I know that you're a star. And I'm just excited to see your career develop. So, and she'll be at Alabama next week. She'll be at Alabama next week. We have a symposium on the celebrating the anniversary of the Civil Rights Act and dealing with gender and race issues. So she's on a distinguished set of panelists, so we're excited to have her too. And thank you, Mrs. Bell. Just your presence and just watching you move around and upholding your husband's legacy is really inspiring to me. He inspired me as a student when I was in law school at Tulane. I took critical race theory, and it gave me kind of the language for ideas that I had and reactions to traditional cases and the traditional case method that we studied in law school, but there really wasn't kind of an environment to talk about that. None of our teachers really talked about race, and when they did, it was quite uncomfortable, especially being, one of just a handful of black folks in the room, just one of a handful of minorities generally in the room. With affirmative action, when it came up in con law, it was always very uncomfortable. But that was just about the only time. Other times, race is there, but nobody's saying anything about it. And as much as, as painful as it is sometimes to talk about race being a minority, I feel compelled to do it. And I felt compelled when I started teaching. I loved evidence law. I felt compelled to discuss it. And to talk about it in my scholarship, knowing that some in the academy may not appreciate what we do. They may not look at it as traditional scholarship, but I think we have a responsibility to discuss it. And so that's what I try to do in my work on evidence. Evidence law, the rules of evidence, is probably one of the most facially neutral sources of law out there. It looks objectively like this body of law that's really about getting at the truth and presenting the truth at trial. But race is everywhere in the rules of evidence, but nowhere is it really acknowledged in the rules of evidence, and typically traditional evidence scholars don't talk about it. Also, critical race theory scholars don't talk much about evidence, so that's where I saw an opportunity to discuss kind of that intersection of ideas, especially in the criminal justice system. Can't get around it in the criminal justice system, the use of race as evidence. And I'll tell you, you talked about students being first. Yesterday, one of my students pointed out when I was teaching a class on a rule of evidence, Rule 609, the race problems with it. And that kind of convicted me as well, that I do need to write something on that. And so that was my first piece on race and evidence. Rule 609 is a very popular rule, and you probably have all seen it in action, but may not know if you don't really remember evidence if you go to law school, or if you're going now, you might want to forget it. But Rule 609 allows for the impeachment of criminal defendants when they testify as witnesses, and also ordinary witnesses in criminal and civil cases to be impeached with their prior records or other records, any other, because it could be prior or subsequent to whatever the underlying charges or whatever the underlying facts that gave rise to the case are. But if you have a record, most often it's a felony, and there's some narrow circumstances where misdemeanors might count as well. Those can be used against you if you testify, even if it has nothing to do with the case, okay? That can be used against you. And the theory is that when you have a record, that it goes to your character for truthfulness, okay? That you're less truthful because you committed some act, even if it had nothing to do with truth-seeking or truth-telling. You're still considered to have poor character for truthfulness, so we can impeach you as a witness. It keeps a lot of criminal defendants off the stand, and frankly, it forces a lot of them to plea out because they know, and there's been actually a recent study that proves what I'm saying. They know that they're likely to be convicted on the basis of the prior record in the first place. And so that student, get back to the story about the student, pointed out in exasperation, she's an African-American woman, pointed out the problem with the rule. And she basically said, to paraphrase her, you know, Congress is largely a group of white men who just don't get people of color, and they don't understand, or they choose to look the other way with respect to the application of this rule. It has a serious racial implication. And you know, as I studied it, I found that there was a history behind the rule, that it was really a compromise historically with respect to old competency rules. We had old competency rules that kept a lot of people off the stand. Black folks, you couldn't testify at all, especially at a trial against white people or involving white people. You couldn't testify against them. It kept civil parties off the stand because you were thought to have an interest in the case. People thought you would lie just because of the money that was involved. And it kept criminal defendants off the stand. And eventually, those rules were abolished. And one of the reasons that they were abolished is because as more and more, you know, we started to see African Americans get their freedom and to start to gain rights, there were some who didn't appreciate that eventually a black person might be able to testify at trial, but a white criminal defendant wouldn't. So you see how blackness is on par or equated with criminalization? And so there's that history, that root, and I could go into some more, but that's really not the subject of my talk. I'm just telling you why I got into this. There's that history. I loved the way Professor Lopez put it yesterday about the adaptation of racism. And if we think of racism as a disease, a dis-ease with other people who don't look like you, then it has to adapt to survive. But when it adapts, it becomes harder to deal with, okay, because it gets stronger, and it's harder to root out. So that's what's happened with 609. 609 was just a compromise. It said, okay, we'll let you testify. Black people can testify, criminal defendants can testify, people generally with records can testify. The kicker is, when you get on the stand, though, we're going to bring up your record, okay? Which means that if you're a criminal defendant, you're likely to be convicted anyhow. Okay, so it's like it operates in a similar way as it used to. So it basically keeps them off the stand and forces them to be convicted by their prior. It operates very similarly. It's just adapted. Okay, so that's an example of race as evidence. Okay, that's an example of race as evidence. If we look at the history behind who is more likely to get a felony, there's studies that have shown that black people and Latino people are more likely to get a felony for the same behavior as their white counterparts. Their white counterparts are more likely to get deferred adjudications, not charged at all, et cetera, et cetera, et cetera. Race is evidence. Race becomes the 609 evidence that's then used to reconvict. Okay? So 609 is a character evidence rule. And so one of the things that was in that first piece that I did on race as evidence was that race is character evidence, and then I got into talking about 609. But it's bigger than that. Okay, it's bigger than just 609. Race generally is character evidence. The rules of evidence formally say, with the exception of 609 and some other exceptions, that we can't use character to prove that someone acted in conformity with their character on a particular occasion. Generally, we keep it out, but we have exceptions. We have ways to get around it. And my whole theory is that race is a huge way that you get around it, but we don't acknowledge it. A criminal defendant, if they're African American, by coming in the room, that's evidence. That's a presumption. And we don't even talk about it. We act like it doesn't even exist. Out on the streets. Well, if you want proof, let's go to New York, right? Let's go to New York and we'll talk about stop and frisk. And it's been in the news a lot lately with the, the debate over whether they should have the policy. Think about that op-ed piece that Ray Kelly wrote in the Wall Street Journal. Y'all remember that? He said and defended the use of a person's race as evidence to stop them, even if they didn't do anything wrong. Even if they didn't do anything wrong. And he took credit for this policy with respect to crime reduction. Okay? And then, and to me, one of the most telling and remarkable parts of the Wall Street Journal piece, he acknowledged that it's, quote, understandable that someone who has done nothing wrong will be angry if he is stopped. Nevertheless, we should keep doing this. Okay, and as a spouse of an African-American man who looks youthful and wears urban gear, I've seen him stop. I've seen him stop walking in the gas station. We were on our way home from Alabama to Louisiana. We went through Mississippi. Cleveland, Mississippi, we're at the gas station. He gets stopped and he has to show his driver's license to a police officer on his way from pumping gas to going into the store. And he's really kind of even keel about it, or pretends to be. And I said, well, what happened when he got back? Because I'm in the car with my little kids. And he says, oh, just life of a black man. That's what he said, life of a black man. And it stuck with me for a long time, and I've seen other instances where he's been treated that way, where we've both been stopped, and the focus has really been on him. Ray Kelly doesn't get the psychological damage that you're doing to people, and maybe he doesn't care. I don't know, but I don't think they get the true psychological damage that you do. So it's not just understandable that they'll be angry, but this is an offense. It's an offense that occurs over and over and over again. And these are people who have done nothing wrong. And Ray Kelly admits these are the type of people that have done nothing wrong. The hit rates show that this is really not efficient. Okay? And I don't have time to get into it in depth, but it's not an efficient way of reducing crime to just stop someone on the basis of their race, using their race as evidence. But that's the type of mindset, the type of culture that we're living with. And we have leaders in our country who think that it's perfectly okay to use race as evidence of character in stopping them. So you have that. And then that's incorporated at the trial level. in court, in the judicial process, and we also get it in the media, which brings us to the Trayvon Martin case. I couldn't come up here and not talk about what to me is the most obvious and disturbing examples of the use of race as evidence kind of on every level. So we have George Zimmerman, who I do think used Trayvon's race as evidence, because we use it too. We just in interacting, not necessarily in the law, the legal context, in the legal community or in court. People, just ordinary people, lay people every day are using race as evidence of character to make decisions, life or death decisions in the case of Trayvon Martin. So his decision, I do believe, was in large part based on the race of this young man, how he was dressing, how he appeared to him. He appeared scary to him. And, it's troubling that the way the case played out in the media on so many different levels. I kind of see everything through that lens of the rules of evidence. So generally, we're not supposed to use somebody's character as in evidence law as proof that they acted in conformity with that character on a particular occasion. So generally, we're not supposed to judge a book by its, quote, cover. And what does this cover mean anyhow? What does it mean to be scary looking, or to look like you're up to no good, or or to look like an effing punk, or whatever he said about this young man? What does that mean, and where's your proof of that? Okay. What he did was then confirmed, I think, in the media, and I'll be critical for just a second, and I'd love to hear comments, what you all think about it. And I get why they did it, of his supporters when they first presented him to the public, Trayvon supporters. The first picture that you see of him is kind of, all-American kid, much younger than what he was at the time, because you have to present an image, right, in order to get folks' attention. Character, okay? So he has to have, or appear to have, what we think of as good character in order to even get the attention of the media. But we saw it backfire, right? We saw it backfire. And every time you see that picture, I love to read comments after these articles, because it really tells you where we are in this country. Why do you keep showing that 12-year-old picture of him, And one of the comments said, because if we show this other picture, then you confirm what we already know, is that big, black, and scary Trayvon deserved to be killed. That's what that has to be what you think if you're concerned with us showing the 12-year-old picture. So I think that it raises all kinds of issues, like with the civil rights community. When we present someone in that light, what are we really saying? When we present Rosa Parks and not the young lady who was the cussing, pregnant teenager, what does that mean? Okay, are we confirming that? That people who don't conform to kind of the ideal of what good character evidence should be, are we confirming that? And then what kind of standard are we holding ourselves up to if that's the case? It raises a lot of different issues that I think we need to think about. Again, going back to the Zimmerman case, I want to talk, get away from George Zimmerman's actions on the streets and talk about the activities at trial. You really, literally saw race used as evidence. And there are a couple of issues that I want to highlight. One, obviously, the treatment of Rachel Jeantel, that young woman who was an ear witness. To me, the most credible witness, but was perceived as the least credible witness because of the way she looked, the way she talked, and then the attorney for George Zimmerman was able to, I think, use that in a way that presented her negatively to the jury, and he knew that the jury would perceive her in that way. If you listen to Juror B37, her Anderson Cooper interview right afterwards, she talked about Rachel Jeantel and Trayvon as they, and talked about George Zimmerman as George. So you have George, that shows that there's that personal connection, and then you have they. And she talked about the way they were living. She felt sorry for Rachel Jeantel because she thought Rachel Jeantel felt like she was out of place in the courtroom. Where do you get all this? Where does that come from? Because everything about her, based on stereotypes, was a type of character evidence that the judge didn't, and I believe had to have known that this is going on, but didn't do anything about. And then you had, to me, probably one of the most remarkable exchanges in the court, where a neighbor of George Zimmerman, who was a white woman, came in and testified basically as a character witness for him, and also a positive character witness for George Zimmerman, and also a negative character witness for Trayvon, whom she didn't even know. Remember, if for those of you who watched the trial, what she talked about? She talked about a robbery that had occurred in her neighborhood, committed by allegedly by other black youth who Trayvon didn't know, and certainly she wasn't alleging that it was him, had nothing to do with the case at all, except this implication that somehow, because Trayvon was black and young, and I guess looks like these unknown black youth out there that she encountered, and I'm not making light of her experience, but still it's disturbing that it was brought up in this case. What does it have to do with him? Except that he's associated with them because of race, and then race becomes this character evidence, and it went completely unchallenged. The judge allowed it. There was no real cross-examination as to why you're talking about this. Very, very, very disturbing. It was really blatant to me, the use of race as evidence. And I guess the most perverse part of it was that the judge didn't allow the word racial profiling. I think she allowed profiling, but not racial profiling. So you take race out of it formally, but it's all in there. Okay? And another way, to me, one of the most subtle ways that race was character evidence was George Zimmerman also had a character witness who was black who never got on the stand. Y'all remember the intern that sat at the table? The black intern who sat at the table with George Zimmerman's defense? That's a character witness. Yeah, that's because by not saying anything, she just comes in, she doesn't work for free. She comes in, doesn't work, doesn't say anything, but she's carrying a really significant message. He has black friends and he's not racist. And I validated him by my very presence. She actually did an interview, a CNN interview, where she effectively said that she didn't think he was a racist. So she's this amazing character witness for him who isn't subject to any of the character evidence rules. There are all kinds of rules. There are exceptions that allow criminal defendants to have character witnesses. They can open the door because we're concerned about them and supposedly about their rights as criminal defendants. We want to give them every opportunity to effectively defend themselves. But she's able to come in and basically be this witness, and none of those rules apply to her, because the rule is that once they open the door to good character, we can talk about their bad character, the defendants. So you open the door, you talk about how good you are, we can bring somebody in and talk about how bad you are, but we never have to deal with that rule because she's just sitting there and she doesn't say anything. But trust me, she was a witness. And don't think for 1 minute that jury didn't see what all of us saw. And it was played really well. And this happens a lot generally. Just zoom out for a second. African American attorneys are often asked to sit at witness or at counsel tables, a lot of times doing nothing. When there's some black party against whom that the representation, whoever they're sitting with, that representation is dealing with. Okay, so often that happens. Paul Butler talks about it as a black prosecutor. In his book, Let's Get Free, he talks about how he knows that there were times that he was in the courtroom trying cases against black defendants because he was black. And so if you think about race as always being on trial, regardless of whether the criminal defendant, whether the criminal defendant is black or white, if race is always on trial, and that's my theory, I believe it always is, we're always having to prove our good character, disprove our bad character. If race is always on trial, then Paul Butler, in his article, in his book, when he talks about being a black prosecutor prosecuting black defendants, was a positive character witness. Okay, he was disproving, if you will, the black criminalization. He was disproving that narrative. Okay, and then by him disproving that, he stands in direct contrast to what he calls the cretin, who's on the stand with the bad diction, the baby mama, not married, all that stuff, all those stereotypes. He's like the direct contrast of that, okay, which allows you to get that conviction. We see it all the time. It's like, what can we do about this? It's a huge problem, and I could go into more depth, but I got 2 minutes left, so I had to get off here, go back and sit down. What can we do about it? I think I'm on the wrong panel because I don't know that there's an interest really to fix this. With respect to people who don't have to deal with this, I should say. I really don't know that there is a substantial interest to deal with it. And so that's what I struggle with. I have theories or proposals for how to fix it, but I don't know that anybody wants to. When you have a judge in the case that's being looked at, not just in this country, but all across the world, who won't even allow the word race to be mentioned, and so who certainly isn't going to have a discussion with the jury about race, which that's what I think they ought to do. Let's have an open, frank discussion and talk about the use of race as evidence everywhere, and that this is a huge problem. We probably can't completely get around it, but you at least need to acknowledge and be aware of it. This woman who's sitting at the council table, she doesn't have to get up and talk, but she is, in effect, a character witness, and you need to evaluate her as such or understand that she is as such. I think that's the way to deal with it. But who wants to do that? I don't know that anybody really wants to do that. And so I guess I end on a pessimistic note, but a realistic one. I have a theory for how to fix it, but I'm not sure if the interests are aligned yet to do it. So anyway, I look forward to comments and being able to talk more about this issue. Thank you, guys.
Good morning, everyone, and thank you all for being here. Very honored to be here and to be a part of this panel and symposium. I would first like to start off by thanking you all for being here this early in the morning, and also to Jasmine, who's just been tireless and must have exchanged 100 emails to get to this point, and also to Caleb and to Professor Jesse Allen, who's hosting me. I very much appreciate the hospitality. So I guess what I would like to, in a nutshell, explain how we can use interest convergence to understand what's happening with our approaches to imprisonment. So I'm looking at economic interest convergence in downsizing imprisonment. So I'm using it as a lens to not just to describe what's happening, but also to look into the future of what is likely to continue happening with respect to imprisonment. So what I would like to do is just start off by talking about the different interests that are at stake. I call this economic interest convergence, just to set out right at the beginning what kind of interests we're talking about. We're talking about money, right? So I want to lay out why I think that money is going to be what actually reins in the criminal justice system. I mean rein in two ways. It's going to rein, and it's also going to rein in. So what sort of interests are we talking about? So I think about it in terms of costs, like the costs of imprisonment. And so when I say costs, I mean metaphorical and literal. There's multiple and layered meanings of costs. So for proponents of downsizing imprisonment, cost can take on these various meanings for fiscal reformers. And so I'm breaking it up into basically three different groups when I say that there's interests converging in downsizing. So the first group are fiscal reformers, right? Imprisonment costs a lot of money. I'll get to how much it costs. So there's the cost, so balancing budgets, spending, saving money, these sorts of things. So that's one group. Other group is people like me. I've been sort of barking about the conditions of prison for about a decade now, and nobody really cares about that. Sort of what is the social toll for imprisonment, what happens to prisoners once they get inside prison, those sorts of effects. So I'll talk more about that. That's another group. And then you have more ideological groupings of people who look at this as just another expansion of government, right? It's big government at its biggest, at its most expensive, right? Libertarian ideas about intrusion in the lives of citizens and that sort of thing. So these are more ideological reasons. And so my argument is that it's the money that's going to win out in the end. It's economics that are going to play out and actually determine the future of criminal justice reform. So for fiscal reformers, cost is literal, the spending that goes into incarceration, right? And so the dollars. For more skeptical folks, prison supports a form of public welfare, fueling a system that clothes, shelters, and feeds the poor. For communities that have felt this harsh whip of punishment, costs includes all of the above. Right? So we're talking about economics, the political, physical, and mental health of communities. So the first thing that I start talking about in this work, and I was very excited to be a part of this symposium because I've been thinking about this for a little while, looking at a lot of things that are happening in the legislatures and in courts as to how prison populations are being reduced. And so this symposium comes at a great time for me because it allowed me to sort of work on this idea and work it out. And I'm really looking forward to your comments and questions at the end. I mean, we have a lot of heavy hitters in the audience right now. It's almost intimidating to be up here with the critical race. You know, there's like a serious brain trust on my right, and it's a little intimidating, but I would really look forward to hearing from you all about how to improve this thesis. What kind of costs are we talking about? Before we get into that, I guess that, I want to think about the forces at play. And so what is sort of unspoken in Professor Bell's theory is that the struggles that are going on are largely struggles that happen between white forces. Right? It wasn't people who were opposed to the Brown decision were whites in general, right? And so that's the same sort of struggle we see today. The powers that ultimately determine the outcome of prison reform are largely struggles between white forces, right? Like in Brown's era, when white Southerners opposed civil rights and racial equality, today there are formidable forces in opposition to prison reform. As racial oppression was in the South, mass incarceration has been profitable for whites, including tough-on-crime politics that have built many political careers, and tax dollars that have provided jobs to depressed rural regions, enriching construction company coffers and providing wealth, right, for private prison corporations. Over the course of the last 4 decades, the correctional system has funneled billions of government dollars into the hands of white America. Right, so that's the set of interests that we're talking about. It's like, where is this money going to? Well, it's largely going to jobs and to private prison corporations and service industries and all of this to make the prison industrial complex work, right? Now, whatever side comes out, whether prisons downsize or whether they keep expanding, whites are the primary beneficiaries, and that's one of the points to make. And of course, this thesis is going to be intelligible to the extent that you recognize prison is a racialized space for black and brown bodies, and the government is white. Right? If you don't believe, if you don't sort of buy into that, then my thesis won't make any sense. So that's the juxtaposition here. So, what kind of costs are we talking about? And so we're talking about all-time highs, right? So we're talking about more people locked up than any other time in human history that we can look to right now in the United States, outside the context of war, of course, but we've got over 2 million people locked up, so it's huge. It's the largest prison operation in the world, right? One report has noted that corrections is second only to Medicaid as the fastest growing general fund expenditure, right? In 2011, state correctional costs were $52 billion annually, and the total aggregate of state spending on corrections is 6%. So 6% of state budget on average is going to corrections, the majority of which funds incarceration. At the federal level, this is almost $4 billion a year. So a lot of money is at stake here. So those are the sort of costs, the interests, the financial interests that are at stake. Now, of course, the communities from which prisoners come have huge interests at stake in seeing less imprisonment. I could go on and on and on about collateral consequences, about the physical, the mental health of these communities, and it's not a very pretty picture. Prisoners have the highest HIV rate in the country of any group, followed by the communities to which prisoners return. The political health of these communities, same thing. The voting power is weakened tremendously by felony disenfranchisement. Over time, Latino and African American communities. Right, it's just another iteration of keeping people from voting, but it's focused on these communities. The mental health issue, lots of mental health problems in prison, some of it's caused by prison, and these people prisoners go to the same communities from which they come. It's a cycle. So the problems that arise from imprisonment go back and hurt these communities, so they're hurt economically, politically, and in terms of health. And my sort of work has been about showing this relationship between prisons and the communities that prisoners return to, and it's all about systemic harm. It's structural damage that occurs. So that's the part that I'm done talking about. I'm done talking about what prisons do to communities and what they do to prisoners, because people don't care about that. So I've had to change my tune over the years and talk about money, because that does ring bells with people. And so now I want to talk about, well, how can people like me sort of get other folks to buy in on this interest convergence? How can I get them to, because it's not a very righteous or sort of altruistic reason for downsizing imprisonment, right? To save money. It's like, wait, families have been ruined, lives have been lost, communities are devastated, and we're worried about money now, right? I can find a million other reasons to downsize imprisonment, and it has nothing to do with money. So altruism's not a part of this equation. And so ultimately, we have lots of reasons, rationales for reducing imprisonment, but economic interest convergence suggests that money is going to reign in the future. So that is a sort of my explanation in a nutshell. And the signs of the time point to money being the decisive factor. If you look at legislatures, they've really focused on diversionary legislation. They've created sentencing commissions in order to sort of bring down the lengths of sentences, bring smarter sentencing to the table. You can look at the judiciary, helping to develop problem-solving courts, right? Diverting drug offenders, mental health offenders, people who have mental health issues. In Missouri, the Sentencing Commission has explicitly called for judges to look at cost as a sentencing factor. You might say, whoa, cost as a sentencing factor? What does that have to do with anything? But that's sort of a part of this trend that's happening. And of course, the executive branch has been taking measures. You have police forces developing like civil citation programs, and you've there's more work to be done from the executive branch. I think that's the weakest. But you can see that the government branches are exploring different ways to divert people from prison and to bring the prison population down. Now, of course, the kind of cruel joke in all of this is that because you reduce prison population, that may not actually lower the price. In fact, it may raise the price of incarceration. So just by reducing prison populations doesn't mean we're going to reduce money. But that's not what the talk is about, because the perception is that you reduce prison populations, you're going to save money. So that's it. And I guess the takeaway from this, there's two takeaways. One, there's just a sort of, academic, normative, where does this point to? Well, I can think of a number of other ways that the branches of government can implement programs and policies to save money. So for the executive branch, for example, the use of clemency and powers of commutation are not used in a systematic way. Police officers can use more discretion in terms of whether this is serious enough for an arrest, to press charges. Prosecutors can use their prosecutorial discretion in a more systematic way as well. Right, so there's that. The judiciary is the same. So I've got those where we can point to the future, but I guess the real point is that prison reformers of all stripes need to recognize that even if it's not for the most altruistic reasons, right, the humanitarian, even if it's not for those reasons that prisons downsize, it needs to happen by any means necessary, right? And so that's the point I'm trying to drive home, is that ending American exceptionalism, right? Exceptionalism meaning that we're way off the charts in our punishment practices. We're not even close to the we used to be, right, in historical America. We're 5 times more punitive than we used to be just a few decades ago, and we're about 5 times more punitive than most Western democracies. So we're just sort of off the charts on our own. And so for these communities that have to deal with all of the systemic problems of incarceration, by any means necessary, really, by any way that we can reduce prison populations, we need to do it. The last point I will make is that even if we do reduce prison population significantly because of cost cutting and spending reductions, Professor Bell's thesis doesn't guarantee anything. And that's just the last thing I would like to bring up, is that using economic interest convergence as a way of understanding this situation right now doesn't guarantee anything. It doesn't guarantee that politicians don't foment another renaissance in punishment, right, among the populace. It doesn't guarantee that once money comes back into the coffers, we will start reincarcerating at these rates again. It doesn't guarantee against any of that. So even though this is happening, it doesn't guarantee anything in the future. So thank you for your time and your patience. Appreciate it.
So thank you. And coming in here this morning and looking at the need for application of critical race theory to these areas, poverty, imprisonment, and traditional doctrinal areas of law, such as evidence rules, which have not been viewed under a lens of critical race theory, and that present need for that further exploration. So here, not only are we talking about contemporary issues, but we're also exploring interest convergence. And so we had Professor Crowder talking about reconceptualizing interest convergence as this strategy to addressing poverty in a very practical sort of way. And then I'm hearing Professor Carodine talking about, I don't know if there's an interest to fix this. And ultimately, we have this Professor SpearIt. He's talking about understanding interest convergence doesn't guarantee anything. So what I want to pose before I open this up for questions is interest convergence something constructive or deconstructive or something else? So when I look at Professor Bell's work in evaluating Brown versus Board of Education, I'm seeing an explanation that, no, we have not arrived. And those of you who heard Megan Block talk yesterday, and she talked about her student, her fourth grade student, who made a poster celebrating Black history, and it was about Brown versus Board of Education, and asked what that case was about. Because the school that that little girl was in was a racially isolated Black school. So how have things changed? So in looking at Professor Bell's explanation and contradicting that traditional narrative that we have arrived, everyone, because we have Brown versus Board of Education, things are solved, and saying, no, let's look at what happened here and interest align with elite rights. So as we seek progress, should we be trying to find interest convergence? Should we be saying that by appealing to these majority powers, that this is the aim that we should seek? Maybe. I mean, when I hear SpearIt talk, and I like how he acknowledges that, but maybe not. Maybe the interest of justice is not always appealing to those interests and finding that ground. I think that Montré has a pretty good solution here. Maybe some people aren't going to like it, but it'll be the right thing. So I just want to start out with talking about, is this something that is constructive, that is positive, that we're seeking, or is it a tool to understand the realities, or is it something in between? So let's start that discussion, and then let's enter. So let the panelists respond, and then let's have a conversation here, and let's ask questions and so forth. Now I realize there's not a mic on the table, so I know that professors, they don't have loud voices, but let me know if you can't hear them, if I need to repeat the questions and so forth. Okay? So some people want to take a stab at that, and then we'll open this up here.
I'm happy to say so.
Yeah, can people hear?
What you're pointing to is one of the major debates about this theory. I mean, what is it? Is it descriptive or is it prescriptive formula, right? This is something that, right, are we just, I mean, you had defenders of Professor Bell saying, look, he was describing a situation, not describing a strategy, right? And Cynthia Lee sort of talks about this and draws out these. So, yeah, I mean, it's great for us to have this discussion.
Wonderful.
Well, I'd like to pose the notion that, yes, we do need to re-interrogate the notion of interest convergence, especially from the framework that Derrick Bell is looking at it from. If we're talking about Brown versus Board of Education, we're talking about the Cold War, we're talking about the United States, capitalism versus communism, and their standing in the world, and the idea that we promote a meritocracy that we don't actually have. And so in 2014, can we say that that's different? And that we know that we are still in a global competition, energy crisis, capital crises, etc., where America's standing in the world is being questioned. We still suggest that we are the human rights progenitor to the world, yet these instances that all of us talk about demean or discredit this claim of meritocracy. So that is the interest, generally speaking, that we're working with. However, so I think we need to interrogate whether we're talking about a global context for interest convergence, which meritocracy seems to be that linchpin, versus more precise interest convergences, whether when it comes to economics on a local, state, or even just in terms of federal level.
Good. Yeah.
I had a question.
As loud as you can, Justin.
Okay. My question is also on the same topic of interest convergence, especially in the context of mass incarceration. What do we lose when we advocate our moral arguments? I think about Brown and how, let's say, for example, instead of arguing for equality, the lawyers argued that in a Cold War context, we had to help America's image abroad. If you lose the principled argument, when you have the inevitable
retrenchment, as you said, as SpearIt said at the end, when the coffers fill up again, what's going to be there to stop the backtrack to mass incarceration again once there's more money, or who knows, maybe by then they'll have drones and they can just fly around and zap people or something. You know, if you lose the principal argument, you lose the basis for future organizing. When you think about how the civil rights movement, a lot of the organizing that took place in the late 50s, early 60s, was based on some of the principal arguments laid forth in Brown and some of the moral arguments. So isn't that a danger if we abandon our ethical argument for appealing to sort of the base economic approach and using interest convergence as a strategy as opposed to simply an analysis?
Great, thanks for that. So I would never suggest abandoning moral arguments. What I'm simply suggesting is that what's going to win out in the end is this. But of course, I've sort of abandoned it because I've been talking till I'm blue in the face about prison conditions and this and that. And so that's an old story. So I think those arguments are there. I guess I'm thinking about more how can cross-pollination occur with these rationales, right? So how can we, so for the fiscal reformers who don't really care about any of the things that I've mentioned, how can they sort of embrace that as an additional rationale to also buttress their fiscal arguments? But at the same time, how can we turn those people into critics of the prison system as well? So how can each side help the other come across? And I think that's really what this is helpful in doing. Is, you know, as oddly as it sounds, there was a New York Times article not too long ago outlining all of the different reasons Tea Partiers and conservatives need to be in favor of downsizing and imprisonment. So how to get those people to join people like me and how to, so I think that's really what we're, not to abandon anything, but to cross-pollinate.
Any other comments at the panel of some of the questions here posed by Professor Montré Smith and just answered?
Just some, I guess, thoughts that come to mind.
A little bit loud.
Some of the thoughts that come to my mind are, of course, the moral argument is crucial, but I also am a believer in, addressing a problem by getting to the root of the problem. And one of the roots of racism is economic. It's an economic advantage to cast people as the other. And so when we can show you that that's not working, then I think that that's a good thing. But it's advantageous, and that's one of the things I learned in one of the first things I learned in my critical race theory class as a student, is that it was advantageous to cast to black folks as the other, because you can enslave them and do free work. And then the moral part, lazy, criminal, all those other things, were justifications for this economically advantageous institution. So you can show, and then it just morphs and adapts into mass criminalization, where we have prison industrial complex, they're making all this money for corporate interests. But when we can show that that's not really efficient or it's not working, I think it's a solution to the problem by getting at the root of the problem, or part of the root of the problem. So that's a thought. The other thought was a global question, just a thought that came to mind. I don't know if it fully addresses it. In some ways, I feel like we have no shame anymore, which, we have the 24-hour news cycle. When I get to one of the things that I talk about in the paper on racist evidence is also entertainment evidence. Evidence is entertainment. Trials are entertainment. So we don't have any shame. It's like that's an advantage to have this big trial of the century again. And it's about race, and then we don't want to say it's about race, and we have this debate, we have articles, and we have 5,000 comments. I mean, that's like big business. And so we don't have any shame. When we find a way to shame people for doing this, then maybe you can get back to the kind of the interest convergence and the kind of the global shaming of America. But right now, like we saw in that one case, no shame.
Yes, please.
I have a general question to the panel. The comment first that our existence is dynamic. We're always changing as a nation and as a people. It occurs to me that in those changes, there are new kinds of questions. I refer specifically to Mr. Robinson's book called Disintegration. I don't know if you know the book, but he posits 4 or 5 kinds of the population. There's a transcendent population now, multi-millionaire, ultra-rich types, and they live in another world. They're not part of the black community, although they're part of the black community. They are out of the problem. Then the hardworking types striving to make it. But the last category is called the abandoned. And it seems to me that's a large category and growing, and it's primarily African-American, Hispanic, and the like. And I'm having trouble, although I'm a fan and a longtime friend of Derrick Bell, I'm having trouble applying the scientific method of interest conversion to the hard reality called things change, stuff happens. Like place I say stuff. And case in point, as a former practicing lawyer, trial lawyer, I make the point that we don't try cases the way we used to because television has corrupted it. Judge Ito was playing games on his computer during the boring testimony about DNA and stuff. And we now have lawyers who have absolutely no compunction about asking leading questions and no one objects. So it is true that you felt that you were really under great pressure and that's why you had to bring out your gun to shoot that boy as he was grappling with your neck.
Yes.
Wait. Leading for crying out loud. So as we change as a nation, we're also changing the rules and making them more simple to break. Come on.
I just have to jump all over that last part of what you said. I just jump all over the last part of what you said because the trial is entertainment now.
Exactly.
And our pain is your entertainment. And that is really, really, really disturbing. And it does change the way that lawyers try cases. One of the best trial lawyers that I had ever seen when I was in law school at the time, one of the first questions that she would ask a jury on voir dire is, what law TV shows do you watch? Because she wants to know what your expectations are. Now you got to ask, what trial in the century have you watched? Because that changes the expectation. From the perspective of what I do in talking about evidence, it really changes what we expect out of black criminal defendants and about what we expect to hear about black victims. Now you do need to, one of the juror B37 said she didn't know what kind of boy Trayvon was. Well, part of the problem is they can't talk about that because of the character evidence rules. Because if you talk about what a great boy he is, then you got to talk about the suspensions. Okay, for marijuana, which there's a whole body of law that talks about black boys being suspended at a higher rate than white boys. So, I mean, there are all these race issues that come into play with how that case is tried, but we can't talk about it, and then this becomes the standard. So now, we expect to hear what a great boy he is, and, or we think it's okay if he's not considered a great boy to go out and kill him. And then you have that Dunn case I didn't even get a chance to talk about. That comes in and just confirms the same thing.
Music?
The loud music case in Florida, stand your ground, same thing, disturbing, 17-year-old boy, pretty much the same thing that happened, arguably worse, under the facts. But it establishes this standard for what we expect the evidence rules to do, which is nothing, in the face of strong bad character evidence about the black race, what I call the mischaracterization, but I completely agree with you. It has changed the way we try cases in this country.
I guess I would add also, I guess I'm a lot more skeptical than you are about some of these issues because, for example, in my criminal law class, we get to, the burdens of deduction, burden of persuasion, burden of proof, right? So we're looking at that. And I have to sort of just pause and say, okay, you realize this isn't law now. There's almost none of you ever try any criminal cases. We don't try criminal cases anymore. Everybody plea bargains out. So in some ways, a lot of this is a moot point because very, very few defendants are ever taking their case to trial. So I guess I'm a little more skeptical on that.
And if I could add just one thing to that, though, but it affects how you plea bargain, though. Seeing what just happened,
Sure, yeah.
Seeing that black is criminal, and if you got a record, you're black, as a criminal defendant, when you see things like this happen in the media, it makes you more likely to plead. Because I think Martin was on trial, Trayvon was on trial. So if you look at him almost as a defendant, that's who you're equated with. And so that feeds into the plea bargaining system.
What I would add to that is sort of just, from my perspective, viewing interest convergence as a strategy. As Cheryl Cashin has written about in terms of sort of the idea of interest group convergence and as a regional organizing strategy and a way to have black and brown people form progressive political coalitions, which I think viewing it as a strategy allows for the flexibility that you mentioned, right? Because the strategy is adapting as the circumstances are adapting. I can't speak to the trial perspective because I'm not a litigator, but I do think that the strategy perspective allows for adaptation and for flexibility, is what I would add.
Justine Ross?
Yes, I was just thinking about this when Patience Crowder was giving her talk, but if anybody else wants to talk to it, that's fine. The interest convergence, getting back to that, it strikes me that it was modified last night by the talk that Professor Ian Haney gave, which is that we have interests that converge, but because of the cleverness with which race is used, people don't see the convergence. And so it's that hump that has to be gotten over. So recognizing the convergence now is just step one.
Right.
Step two is how you get people to recognize those interests. And I was thinking about it in terms of Professor Crowder's point, because you're talking a little bit about suburbs that were white flight suburbs to begin with, and now clearly they have this connection. But because they were formed originally with the idea of white flight, how does race get in the way of what would otherwise be sort of a natural interest convergence?
Thank you for the comment. I think that that's a very well articulated statement of where we are. We have a situation where there are interests that are sort of being aligned but unnamed, as I think we've talked about. And so sort of getting to this idea of strategy and finding ways because once you name the fact that the alliances occurred, then people, I think, are more receptive to looking for it. Once you realize that the benefit that you're receiving is because of this convergence, then I think that allows for similar types of convergence to continue to take place.
Yes, I think one way to answer your question is in order for others to see, people that are boots on the ground, people that are actually in the criminal justice system or litigators in other fields, is we have to talk about race. And I think the problem is that many of us, when we're in our daily lives, don't want to be the one confronting that difficult issue. Somebody said this morning that Derrick Bell proposed and articulated his theories at great personal cost. There's a personal cost for us to talk about race. And I can tell you from my own experiences that people in the white elites, especially in the criminal justice system, don't want to hear it. They don't want to talk about race when you're picking a jury. They don't want you to raise that as an objection because you're calling the prosecutor a racist, right? I had a personal experience where I was representing a black man who was facing the death penalty. We went and talked to the DOJ prosecutors to try to convince them against seeking the death penalty. His victim was white, he was black. And we used, do you want another black man on death row for killing you? and they looked at us, the white panel of DOJ prosecutors, and said, we are race neutral. We are race blind. So we have to bring it up, and it's hard to bring it up. You want to speak to that?
I'll tell on myself. I've been
Throughout this morning, I've been thinking back to a conversation I had with my cab driver this morning. So he had some trouble finding the place, so we were going around in circles. And at some point, he tells me that he got stiffed this morning by the first person he picked up. And he told a story about how they went from different places. I think it ended up being probably a $40 ride. And the last place, the guy, quote, disappeared. He just said, this is my mom's house, I need to go pick up a suit, and he just went away. He just disappeared. And he kept saying, and I was just so surprised because he was well-dressed, he was articulate, he just kept saying it. And I wanted to say so bad, but he had power over me because he's driving me. I don't know where I am. I wanted to say, was it black? This is a white cab driver. I really wanted to understand why you keep telling me how well-dressed he was and how articulate he was, and why you thought that was enough to assume that you wouldn't get stiffed. And why do you make assumptions about people on the basis of the way they look? We don't need to be having these conversations. But the point is, why I'm beating up on myself is because that's difficult when people have power over you. It's difficult when you're pre-tenure. It's difficult sometimes when you have tenure, when you're still in a process. We face these difficulties all the time. I think the legacy, you're right, of Derrick Bell is that we do have to make ourselves uncomfortable. And so, like I said, I have been truly, this whole time, I keep thinking back to that scenario, and why is it that when we encounter these things, why don't we address them head on? All these times are teachable moments, or time for us to learn and for the people that we're interacting with to learn. So I wholeheartedly agree with you, but it is difficult when people have power over you. Anybody?
And what a wonderful time to learn it is right now this morning, and address these issues head on with courage and take this back to wherever we go. I'm looking at the students, the alums, the attorneys, the law professors, the community members, and all of us engaged in this discussion. And I feel like this has been a wonderful panel to start this morning off. Let's go forward with this energy, with this focus, and please join me in thanking this panel for their thoughts and their insights.